Hi, my name is Darlene Caragay, an MBA student, and I'm here to present to you the employment of special group of employees. And this is for my subject Management and Industrial Relations under the instruction of Professor Mario Brillante Wesley Kabutahe. So under the employment of special group of employees, we have the women, the minors, and the house helpers. But before we proceed to the specific topics or categories, let's talk about the right of the employees. This is from the official gazette of the government of the Philippines, which they feature the right of the employees. The Bureau of Working Conditions, a staff department of the Department of Labor and Employment, compiled a list of basic rights that every worker is entitled to. These rights ensure the safety and health of all workers. We have the equal opportunities for all. The state shall protect labor, promote full employment, provide equal work opportunity regardless of gender, race, or creed, and regulate relations between employees and employers. The security of tenure. Every employee shall be assured security of tenure. No employee can be dismissed from work except for a just or authorized cause, and only after due process. Just cause refers to any wrongdoing committed by an employee. Authorized cause refers to economic circumstances that are not the employee's fault. Work days and work hours. An employee must be paid their wages for all hours worked. If their work hours fall between 10 p.m. and 6 a.m., they are entitled to night shift pay in addition to their pay for regular work hours. If they work over 8 hours a day, they are entitled to a overtime pay. The weekly rest day. A day off of 24 consecutive hours after 6 days of work should be scheduled by the employer upon consultation with the workers. The wage and wage-related benefits. Wage is the amount paid to an employee in exchange for the service that they rendered to their employer. Wage may be fixed for a given period. The payment of wages. These are the wages should be paid directly to the employee in cash, legal tender, or through a bank. Wages shall be given not less than once every 2 weeks or twice within a month at intervals not exceeding 16 days. The female employees. Women are prohibited from engaging in night work unless the work is allowed by the following rules. Industrial undertakings from 10 p.m. to 6 a.m., commercial and non-commercial undertakings from 12 midnight to 6 a.m., or agricultural takings at night provided that she has had 9 consecutive hours of rest. Welfare facilities such as separate dressing rooms and lavatories must be installed at the workplace. Employment of children. The minimum employment age is 15 years of age. Any worker below 15 years of age should be directly under the sole responsibility of parents or guardians, provided that work does not interfere with the child's schooling or development. The minimum age of employment is 18 years for hazardous jobs and 15 years for non-hazardous jobs. For the safe working conditions, employers must provide workers with every kind of on-the-job protection against injury, sickness, or death through safe and healthful working conditions. The right to self-organization and collective bargaining. Every worker has the right to self-organization. Example is to form or to join any legitimate workers' union, free from interference of their employer or the government. All workers may join a union for the purpose of collective bargaining and is eligible for union membership on the first day of their employment. Collective bargaining is a process between two parties, namely the employer and the union, where the terms and conditions of employment are fixed and agreed upon. In collective bargaining, the two parties also decide upon a method for resolving grievances. Collective bargaining results in a contract called a collective bargaining agreement or CBA. Now let's talk about the other government mandated rules for women, minors, and house helpers. For the women, we have the maternity leave. Any pregnant women employee who has worked with the company for at least 6 months shall be granted a maternity leave of at least 2 weeks prior to her due date or the expected date of delivery, and 4 weeks after normal delivery or miscarriage, with full pay based on her regular salary. A total of 60 days is granted for government employees and 60 to 80 days for employees in the private sector. The maternity leave benefit is effective up to the first 4 deliveries of the woman employee working in the company. However, Senate Bill 2982 or the expanded maternity leave law of 2015 has been approved on its 3rd reading on January 18 of 2016. If enacted into law, will grant 100 days of maternity leave for employees in the government and private sector, regardless of the type of delivery. The Paternity Leave, RA number 8187 or Paternity Leave Act of 1996, grants 7 days of fully paid leave to married fathers. This is effective up to the first 4 deliveries of the legitimate spouse. The paternal leave for solo parents or solo parenting leave or the SPL. 7 days leave with pay for every year of service on top of other leave privileges, which are the maternity or the paternity leave. Now we have the special leave benefits for women. This entitles women who underwent surgery due to gynecological disorders to 2 months leave with full pay, as stipulated in RA 97 or 9710 or the Magna Carta of Women. This applies to employees who have rendered at least 6 months of service with the company. On the other hand, victims of violence against women, as stipulated in RA 9262 or the Anti-Violence Against Women and Their Children Act of 2004, are entitled to 10 days leave with full pay. Mandatory government benefits and contributions. These are the following. Government contribution will be automatically deducted from regular employees based on their salary with the following benefits. First is the Social Security System benefits or the SSS. The SSS employees compensation or the EC program has been in place to help workers who encounter work-related illnesses or injury resulting in disability or death. This includes compensation for medical services, appliances, and supplies in an accredited hospital, rehabilitation services including medical, surgical, and hospital treatment, and income cash benefit. More information can be found here in the SSS security system. The Pag-ibig benefits. This entitles employees to avail of a housing loan, calamity loan, and multi-purpose loans that aim to provide financial assistance to their needs. For a full list of Pag-ibig benefits and membership requirements, visit their website. For the PhilHealth benefits, provides financial assistance for inpatient and outpatient hospitalization, as well as the benefit packages for patients undergoing prolonged hospitalization and expensive treatments and suffering from Millennium Development Goal or the MDG related illnesses. If you want to get a detailed list of employee benefits in the Philippines, it's always best to consult your human resources personnel or visit the DOLE website. Now let's talk about the minors. From the Manila or the PIA issued in November 9, the Department of Labor and Employment has released the new guidelines on the issuance of work permits for minors engaged in public entertainment or information related projects. The guidelines assigned by Labor Secretary Sylvester Bello III on October 30th shall take effect on January 1, 2018. Public entertainment or information under Department Order Number 65-04 is defined as artistic, literary, and cultural performances for television show, radio program, cinema or film, theater, commercial advertisement, public relations activities or campaigns, print materials, internet, and other media. Under Republic Act Number 9231, children below the age of 15 are not allowed to be employed in any public or private establishment except when they work directly under the sole responsibility of their parents or guardian, or when their participation in public entertainment or public information is essential. In any of the exceptions, the employer, parent, or guardian should first secure working child permit from DOLE before engaging the services of the child. In Department Circular Number 2, a working child permit is required if the child will be engaged in public entertainment or information, whether local or overseas, and regardless of the child's role in a project. A permit is also needed if the child will be featured in documentary materials unless it is a school-related project and will be engaged as regular extra as part of a crowd and is included in the script or storyboard. The said permit is also required for a foreign child national which will be engaged in public entertainment in the Philippines. The RA 9231 limits children's work time to not more than 4 hours in any given day and not more than 20 hours a week. The working child is not allowed to work between 8 p.m. and 6 a.m. of the following day. Under DO 65-04, the working child permit application shall be filed by the employer, parent, or legal guardian at the DOLE field offices having jurisdiction over the workplace of the child at least 3 days prior to the shooting, taping, and event. The documentary requirements should also include the contract stating the employer's compliance to child protection laws. The DOLE regional or provincial or the field office shall also conduct an orientation on the salient features of Republic Act Number 9231 to the child's parents or guardian and employer prior to the release of the working child permit. The validity of the permit will be based on an employment contract and should not exceed 1 year. Now let's talk about the house helpers. It's been over 3 years since Republic Act or RA 10361 knows as the Domestic Workers Act or the Batas Kasambahay was enacted, yet people are still confused about some, if not most, of the terms. So the guide for you to understand RA 10361 is here. Let's know the what and the why. The Domestic Workers Act is an act that covers the protection and welfare of domestic workers who have long been a part of Filipino culture. It's been in Congress for 16 years and is seen as a landmark law that strengthens respect, protection, and promotion of the rights and welfare of domestic workers or kasambahay in Filipino. So what is a kasambahay or a house helper? A typical kasambahay, they should always be treated with respect since they practically keep you and your house going while you're at school or at work. But they should also respect you. The kasambahay law is here to make sure that happens. The law defines a kasambahay as one of the following: general house help, otherwise known as katulong, the nursemaid or yaya, cook, gardener, laundry person, any working children or domestic workers 15 years or older but not over the age of 18. Anyone who regularly performs domestic work in one household on an occupational basis, also known as a live-out arrangement. But the following, however, are not considered as kasambahay. These are service providers, family drivers, children under foster family management, anyone who performs work occasionally or sporadically and not on an occupational or regular basis, such as the sideline. Now, how to hire a kasambahay? With the passage of the law, kasambahais are now treated as regular employees. This means you'll need an employment contract between you and the kasambahay. The norm in the country is to ask if any of your friends know of someone who's looking for a job. But nowadays, it's better to go through a private employment agency or the maid provider to get rid of all the hassle. The employment contract shall be written in a language or dialect understood by you and the kasambahay and should contain the following: the kasambahay's duties and responsibilities, the period of employment, the compensation and authorized deductions, hours of work. Since we recommend going through a maid provider, the kasambahay needs to submit standard pre-employment requirements with the fees to secure them being paid for the maid provider. And these are the medical or health certificate issued by a local government health officer, the barangay and police clearance, NBI clearance, NSO authenticated copy of the birth certificate or other documents that shows the age of the kasambahay. Now, the compensation and benefits. The kasambahay law sets a minimum wage for your kasambahay. For the National Capital Region, it's 2,500 pesos. For the chartered cities and first-class municipalities, the minimum wage is 2,000 pesos. And for any other area in the country, the minimum wage is 1,500 pesos. Apart from the standard pay, your kasambahay is also entitled to the following after a month of service. These are the Social Security System, the PhilHealth or the Philippine Health Insurance System, the Home Development Mutual Fund or Pag-ibig, and the 13-month pay. They are also entitled to 5 paid leaves after a year of service. These benefits are mandatory and processing. This would need to be done by the employer. If you are paying your kasambahay less than 5,000 pesos a month, you will be required to shoulder the premium payments or contributions. These come with giving your kasambahay the basic necessities like food, shelter, and assistance during illness. You should also let your kasambahay finish their basic education and give them access to higher learning if possible. They can't stay as your mates forever now, can they? And that is actually right. For the termination of service, if you want to dismiss your kasambahay or if your kasambahay wants to leave, there are a few things you should keep in mind, especially if it's within your agreed period of employment. One is the notice should be given 5 days before the date you and your kasambahay intend to part ways. The certificate of employment should be given to the kasambahay that indicates the nature and duration of service as well as work performance. If you dismiss your kasambahay for an unjustifiable reason, like you felt like you no longer need him or her, you need to pay them for the service they've already rendered, plus an extra 15 days of work. The opposite is true if the kasambahay decides to leave without a good reason. Any deployment expenses can be claimed from the maid provider if the kasambahay is dismissed within 6 months of their start date. Here are the valid reasons for you to dismiss your kasambahay before the end of their contract. One is the misconduct or willful disobedience. Next is the habitual neglect or inefficiency in doing their duties. We have fraud, the crime or offense committed against you or any member of your family. Also, any violation of the employment contract. On the other hand, here are valid reasons for your kasambahay to leave you before the end of their contract. One is the verbal or emotional abuse by the employer or any member of the household. The physical abuse, a crime or offense you commit against them. Violation of contract, any disease that may harm your kasambahay and or any member of the household. For more information about the Kasambahay law, please check the Q&A on Batas Kasambahay by Dole. Alright, that's all there is for our employment of a special group of employees. I hope that you have learned something from this video. Thank you for watching.